news. Our first guest, Juliana. Happy to be here.
All right, welcome to another episode of the Droid Duo, or in this case, our first episode of the Droid Trio, as we have our first guest, the purple droid, Juliana Neilbauer, is with us. I'm David Schweidel.
You're the blue droid, and I'm
the blue
Gil.
droid.
I'm the pink droid, and
I'm
Juliana, for today, you're the purple.
I'm the purple. We're initiating a purple droid. I feel so honored. Gentlemen,
Yeah,
I'm in my Q-zip. Is that appropriate droid wear? What do you think?
It's a little high end for droid wear. Though Gil and I did have a deal. If we hit 500 views, he did order me the plushies, so they are on their way.
They're on their way from India.
I love it. I love it.
Yeah.
I mean, I have to get the NFT on that too, right? And buy it with the
That's what we
droid coin,
Gil.
the Droid Duo coin.
We did not create our own NFTs, so that's something we can think about with the videos.
But yeah, so we're very excited to have a real expert today, like an IP lawyer that will tell about her experience, how things go, and we try to look at this and what can we take from this. And I think it's going to be fascinating to hear it. And David, I think you wanted to show like how we got here.
Yeah, so before we dive into that, just to introduce our guest, Juliana Neilbauer is a partner at Fox Rothschild. She is a legal expert in this space of AI. She's also got her a tech background herself, having gone through her own entrepreneurial journey. So Juliana, thanks for joining us today. But just to give everyone a sense for how this kind of trio ended up collaborating, we hit on something, and I don't think any of us realized how big an issue we were actually dealing with a couple of years ago. And so we had written a short piece for Harvard Business Review in their digital edition entitled Generative AI Has an Intellectual Property Problem. And Gil and I brought the marketing business perspective to it. And HBR was interested in us bringing a lawyer on board who could actually speak to the nuts and bolts of what are the legal challenges that brands are going to be dealing with in this space. So Juliana and I had gone to college together, so I reached out to her for her expertise, and we ended up putting this article together. Honestly, I was hoping that this would be the jumping off point for me to do a lot of expert witness work in the space. Hasn't really panned out that way.
No, it hasn't.
Well, you've built a lot of experience and knowledge since, I have to say.
I have learned a lot about the issues of fair use, I can say, as it relates to intellectual property. I've had hours of conversation with our general counsel's office about how the things that I would like to do may or may not qualify as fair use. But Juliana, we'll kind of turn things over to you a little bit to kind of really be able to speak to what is the current legal landscape, and like from a IP owner standpoint, are they in an advantageous position, or is this something that they may need to be worried about? Just one small plug before we dive into that. This is a map that Edward Lee has put together, and I've included the link to his blog at the bottom of the screen. He runs the Substack ChatGPT is Eating the World, and this is actually outdated as of today. I saw that there's another case that he has added to this map. But just to give everyone a sense for how many cases are going on right now and how big an issue this has become, because anyone that is an IP owner, authors, artists, musicians, all of that is intellectual property that has been ingested into these models. And I've been trying to kind of read the tea leaves and understand some of these decisions. So Juliana, hoping you'll be able to give us a lot more clarity on where are we today? Where do you think we're going?
And what the hell does that all means for the future? Like, because I've been talking to a lot of like small businesses that say, what can we use commercially? Like, we want to launch something. Can we use it or not?
It's true. It's true. And so I think we published that article in Harvard Business Review online in February or March, maybe April of 2023.
April.
Yeah.
April. And so in that period of time, we have had not only all of that list of cases that are attacking from different types of works, right? So different historically, copyright, it's one set of rules on a federal level for the United States. So we have that kind of clarity. It applies, the elements of what is eligible for copyright, what is enforceable under copyright is from the owner's perspective, and what your rights are, what they can include that you can retain or license or enforce against infringers has been relatively clear. And but what was always a little bit different was what would rise to the level of fair use based upon the type of work you created. So, for instance, there's been a sense in case law and also in the Copyright Office opinions that if you're a photographer and you make an image, it's much more difficult for someone else to take any substantial portion of that work and not be getting effectively the value of the whole work. And so therefore infringement is a little bit more tilted towards an expectation of infringement and a little bit more protection for the author, because it's just hard for someone to take more than a few pixels of a photographic work and not be effectively stealing the essence, the most of the value of that work. And so they're really well protected, as we saw even in the case that we covered in our article. And then on the other side, we have things that are more informational, like collective works that might be put into a report or a dictionary or an almanac, right? That has enough originality in how it's put together that we give it some copyright protection, but we say it's a lot easier for someone to borrow major parts of the facts or the data or even how it's assembled and say, you're not taking the substantial part of the value of that work. You're not going to be siphoning away potential customers from that an original author. And so we allow more fair use, a broader fair use argument, and it tips a little bit further away from the owner. And then they have music, which is a little bit in between. And we have film works, which sort of have edged towards the photography end of the spectrum. But that was still a little bit of gray area that we were slowly cementing over time until we felt pretty comfortable in the bar on this about how we could comment and advise our clients. Then we have artificial intelligence come on the scene, right? And this just sort of upended everything because now we have to reevaluate on the input side for when we're building and training and creating inference for these different LLM, GPT backends. In most cases, a little bit less than the biomorphic yet, but the cases are really for the LLM backed GPTs. And then also on the outputs of them, right, which is what we also have talked about at length in our article and then in other conversations online that people could find that we've had. The outputs too, like what would constitute an infringing output? So infringing use on the input, infringing work created, derivative work on the output. This is where all of these different cases are fighting. And again, we still have that additional layer of complexity of, well, what type of work are we talking about and how much protection should we give it?
So just to be clear, so what you're saying is that, like, if I'm an author, that's going to be different than, say, Disney owns visual IP, right? Like that are the guidelines are different for those two scenarios?
I'm sorry, are you saying that the type of work is different? If you're an author, like a literary author, is that what you mean? Because I'm sorry, you used author and in copyright, everyone's an author. That's just a term of art.
Okay. So I'm a literary author, right?
Literary
Like I've got books, I've got research articles, things like that.
Yeah.
Disney owns visual artwork.
Yeah, those are two different categories of works, fixed ideas. And so they historically have had different levels of expectation of fair use protection, just because and this sort of ties in, it makes sense. If you're taking a part of almost any part of Mickey Mouse historically that you could take when he was still protected, let me pick somebody else. Any part of Darth Vader that you take is almost certainly recognizable, right? And so you can take a very small part, and the expectation is that you're still getting the full value as if you took the whole thing. Versus if someone takes two sentences out of, or even one sentence out of your, 1,000-page novel, your magnum opus, it's much less likely that someone's not going to buy your novel because they got the full value of your novel from those two sentences. So, and that goes to the commercial, the amount of the market that you are having siphoned away from you by that use. It also goes to the substantiality, right? Like how much did you take? And if we always want to take the de minimis, the smallest amount, if you're going to try to argue for a fair use. And so as an author of a literary work, even historically, even before this AI moment, you had effectively you had more situations, more instances of fair use that would likely apply to your work that you could not block as easily versus if you made a visual work. It's just a bias over time in our system. Yeah. So anyways, we have all this background, right? So now we have this, well, we have a whole new system and we're thinking, well, do we need to rethink how we approach fair use versus infringement versus, licensing rights for all these different types of copyrightable works up here and how they go into these GPT backed or these LLM backed GPTs, how they are used for inference and then the types of outputs. Do we just rethink everything, flip the table and rethink everything? And of course, in the law, we don't like to do that, right? We like to analogize. We like precedent. No one really wants to go out and create a completely new rule.
You mean we shouldn't scrap all intellectual property protections like some tech leaders want?
Exactly.
Well,
I mean, to the point.
namely Sam Altman.
Yeah. To the point where, we're trying a lot of these cases that are very fun, where we're trying to justify with different facts that there was no human author and that the author designation under copyright should attach to the AI tool. That's easily like the most extreme under our current precedent and easiest to throw out. And the Copyright Office has been very consistent saying we cannot have anybody but a human be an author. And I can tell you why, gentlemen. It's not that we're biased against thinking future forward. It's because the actual complete wording and structure of the Copyright Act is so inherently tied in with humans and human rights and lifespans. I mean, you look at this, it's life plus 76 years, or now it's a little bit longer. I mean, we would have to redraft the entire act. There's no way that a regulator can, in good faith, interpret that act to apply to a non-human right now without getting their hands slapped by the courts for having overreached their administrative jurisdiction and authority. And so we'd have to have Congress act. Quite frankly, we'd have to have.
That ain't going to happen anytime soon.
And it's
Well,
not.
like, I guess in 2038, maybe.
Yeah, well, you're a betting man, Gil.
Oh yeah.
I don't
Yeah,
know
I
if
saw the
I'm
headline
not a
today
betting
that
woman on the political system globally right now. I'm
in DC. Come on.
I saw a headline today that the administration wants to strike down the AI regulations that states have passed. So it gives us a sense for kind of the appetite to regulate anything relating to AI. But Julia, can we kind of get your take on a couple of the cases that are out there? So one of them is the Bart v. Anthropic case, which, if I'm reading this one right, it's that they settled, but it wasn't admitting guilt with regards to the IP. It was the way they had acquired the text. It was like, we didn't buy literal copies of the books because we used this shadow library. That's kind of what got them in trouble.
Yeah, and this kind of goes that specific element of the case, which is also quite interesting to lawyers in particular and legal scholars, but hopefully to everyone else who's actually out operating these businesses. What's interesting about that is that it actually relies upon this prior, well-trod and supported in courts expectation that when you, as an individual purchaser of a physical book, you get a license from the copyright owner, the author / the publisher who co-own it, to use and then have secondary use and secondary sale without having to give them any royalty back. So it's a royalty-free license for your ownership, and then you have very broad, you can lend the book to your kids, to your neighbor, and it's fine. You can go sell it to the local used bookstore and you don't owe anything back. You don't have to get permission to do that. And so in theory, yes, you could chop up books and make a poster on your wall if you're a teenager of your favorite pages, or in this case, if you're a business, you can chop it up and like scan it into a system. But if you don't purchase it under that regime with that expectation of license, and you purchase this access to the data of this text in a different way, you might not have that expectation of precedential license to have that broad use. You actually might be buying into a more limited license, which in this case is what the argument pointed to, if that makes sense. And so this is why we have these jokes that now they're going and buying all these books and they're, slicing them up because, again, it's just a historical precedent that the rest of us have benefited from, where we could buy a book and we could sell it to a used bookstore, and that's a commercial activity. Or you could resell it on Amazon and make it a side business, and no one is going to sue you. The author isn't going to come back and find you for making a commercial use of their text.
So if I happen to run the world's largest bookstore and I own copies of all of these books, and I were to build an LLM based on training all of those books, I would be in the clear.
As of that step in that moment, right, where we are in the appeal structure of that case in that jurisdiction, limited, right? So I'm limiting it. I'm saying it depends a little bit. I hate to be that lawyer, but for the moment, if you're going into the Northern District of California, and this again Bart's has not proceeded to trial, there are remaining issues that next court could choose to pick up that issue and refine it. So it's a little bit of gray, but for the moment, you would have an argument of good faith trying to follow the law and doing that. And that's effectively what some of these companies are doing, right? They're trying to buy up a lot of books and a lot of licenses.
So if I've got a
That
first
reminds me-
edition and I'm okay physically chopping it up for scanning purposes, that can have a lot of value.
Could have a lot of value. Now, so there's the how you acquire it and what you're allowed to use it for. And again, this also goes into the analysis a little bit, which is also the more of the direct copyright analysis of, are you, I think if we had that scenario and you push those boundaries in that way and you fully digitize the entire corpus of human literature throughout time, you effectively are creating the fact pattern of the Google case. Do you remember the Google Books case from, 15,
vaguely.
20 years ago? Right. And so in that case, Google's hand was more slapped, that they were going to fully replace the consumer's need to buy any book. And so that was considered too far because they were going to make it all, they were going to scan it and then make it all directly publicly available, or at least I think they were going to say they're going to provide sections, but it was multiple pages. It was
Okay.
substantial amount. And so a lot of people only want to read, the first page of every chapter and kind of get the idea because they have a book report, and then they're done and then they don't buy the book. And as we all know, student purchasers are a huge part of the literary purchasing market right now and will be for a long time. God love them. So we don't want to take that away. And so in that case, which is also good law, in certain elements here still, I think if you pushed in your fact pattern into that realm, that you would be in a different fact pattern than what we have in Bart's, right? Because again, in Anthropic's case, they're not going to then scan all this and directly provide the full textbooks to the general public for free.
Right.
Yeah. Though Google Books still provides a lot of content now.
Yep.
And this also reminds me more like the Google News lawsuit, where they were just like taking that news and putting it on their website, where the news website were losing like the traffic. And that might also happen here. They would say, like, here's the full links are there. They can see like the original content, but still no one will click on them because like most searches will start now on ChatGPT, and I would still lose the traffic.
And this gets us into the fair use issue, right? Because one issue of fair use is it transformative, I believe.
Right.
But another one is the economic impact.
The economic impact, right? So I was saying in a different way, but yes. So economic impact, are you replacing the need for the customer to buy the original work from the author, and you're doing that under a fair use? Well, that sounds quite commercial, doesn't it? Or at least that you're blocking the commercial activity of the existing author. And this sort of beautifully ties in with the New York Times versus OpenAI and Microsoft case to a certain extent, because we're talking about unfair competition. We're talking about, and then they're trying to use a DMCA claim in that case. But in fact, the court dismissed the unfair competition claim from the New York Times versus OpenAI and Microsoft in that case. They allowed the copyright infringement. And even the trademark dilution claims were, it's ongoing. So I won't say they're allowing it to proceed, but they refused to dismiss that case. And so, we're unsure whether, the AI creating a market argument and actually driving more traffic to these news sites by providing, more appetite for the style of writing or the snippets or even the referrals to these different news sources is going to be an argument that holds up as not being a substitute and like siphoning away and diluting that opportunity for market share for these brands, these news brands, because they also have the argument that, in addition to traditional literary works of fiction, in our case, the nonfiction or editorial, which are quasi-fiction, right? These have a shelf life that is much shorter. And so most people don't consume news articles 10 years later, right? There's a period of, 2 hours to 4 days for the majority of readership. And so if you're going to in any way interfere with that commercial activity and access to the end user, the reader, then that could end up, that might be a compelling argument to the courts. They deserve more protection and more limits on fair use than a traditional literary work. The flip side of that is that there's just more facts in this. And so what is really facts and what is New York Times style, writer style? And so, is our output really even recognizable as New York Times other than just giving them a trademark bump because the readership, our users really want to have outputs that reflect that level of quality. So I think that case might even go a little bit more into the trademark realm, and we might get more trademark output as far as law and limitations there than copyright, but we'll see. We'll
So
see.
let me float a hypothetical by you just to kind of get kind of your take on this. If the AI developers, if the Anthropics and OpenAIs of the world were to make the argument that we're going to ingest all of this content to create a large language model, I would think that that would fall under being sufficiently transformative from the original text because it's my text being combined with so much other content. And I comprise a very small part of the ultimate product.
Sure. So that is their argument, right?
Okay.
And some courts have found it so far to be, at least in the immediate review, to be compelling because I think it was Kadri where there was the comment that what could be more transformative. Oh, you know what? Actually, let me stop there. I think it was the Copyright Office report that was put out. I mean, we all know the Copyright Office is a little bit in turmoil right now and has been since September or no, May, when we
Is there
had,
an office
our
now?
yeah, if it exists, because the termination of the head and then the second in command, and the second in command, of course, is she's rushing to put out what would otherwise go through a full process and be a full opinion of the office, but instead it's just a report because she's got to put it out the day before she's probably going to be terminated, which they got it out. So it's not enforceable, but effectively they ran down and told us what they, as the Copyright Office under that leadership, believes should be how a lot of infringement actions or how the statute should be interpreted and applied to AI. And in fact, our second in command has won a case in the DC Circuit Court to get back her job. And at least, and we're unsure of who of the two people in the same role are running things. Long story short, it's a lot of fun. But in the meantime, this report is out there, and it did talk about how what could be more transformative than taking a large work, splitting it down into tokens that are individually unrecognizable as the original work, and then having a new prompt run through that and spit out something completely new. I mean, if you're going to say that there's an ability to have transformation as a fair use prong, then we're hard pressed to come up with a better way to actually execute on that.
So these developers may be in the clear if that's where they stopped, right?
Mhm.
But
No,
no.
the courts are saying, so far we're seeing a trend now, and I think it was Bart's, maybe also Kadri, where we're talking about guardrails. And so
Okay.
this is the big takeaway from today. If I was going to leave everybody with one big takeaway, who's on the developer side here? Not on the author side, unfortunately, this doesn't help you, but is that for those who are building these tools and refining them and building agent layers over them to do specific tasks, in your inference and training or just general training of these tools, if you're building the back end, the courts are really leaning towards, hey, we know that it's going to be hard to not take any of the corpus of all of human data, which we call the internet right now, which where everyone's using, the internet to train. And we need to train these tools. Everybody wants these tools to be smarter and better. We need to validate that these tools can work. This is the way to do it. But if you put in reasonable guardrails on the output, that are deterministic. So we have to program them to actually be a filter step in your application after we have the non-deterministic agent and backend do their magic, right? And use their artificial intelligence or whatever we want to call it today. We do need to have a deterministic traditional software step that has a rule, and the rule just applies. And if it applies at earlier step or at the very end step, effectively it blocks and it filters what the output is going to be so that we don't directly hit infringement categories that your specific service is reasonably and predictably likely to output. So if you know, for instance, that you're creating images, or let's say you're Sora, right? And you're creating video clips, and you know that people are going to put in all kinds of bold-faced, proper nouns to try to refer to certain styles or personalities or humans, right? And that there might be all kinds of different protections, including copyright, that those different proper nouns have over what outputs should be created using their proper noun. Then effectively the tool should have a step that it filters for that and sees that and then does not directly pull just from those sources and give outputs that are just purely derivative of those sources. And it should actually have sufficient transformation step at that point to prevent what we saw in the cases where we have like the Getty case, where we're literally just printing out the word Getty and its copyright onto a completely AI generated image because it's truly just pulling directly from only those sources and making a derivative work.
So
Does that make sense?
yeah, just to kind of
So this kind of ties to what I showed you before the episode started.
Yeah.
Because like I've been playing a lot with these engines to try to replicate Superman without saying Superman. And like it's becoming very easy to create an exact, like even a panel from a comic book. And let me see if I can put it.
Well, and it's because it's in the training data. So
in a way, yes.
Right, like the prompting, you don't have to mention Superman.
Superman.
But when you say red and blue superhero or red and blue, strong physique, you're going to end up generating something very, 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 very close to Superman.
And again, all of this fix of these guardrails on outputs to prevent output infringing derivative works does sort of expect that we're going in a direction where we're going to have a broader fair use on the inputs.
Okay.
And do you see what I'm saying? I mean, no one's
I
saying
want to
that
share
out
for a
loud.
second just to show this how it looks like. So on the right is the original image from a comic panel. And on the left is what Gemini created just from a textual description that doesn't mention the word Superman even once. And I have to say the comic on the left even looks better.
I have to agree with your artistic, subjectivity there, but I will say this looks like a case of terrible guardrails. Honestly.
Yes. Yeah, but the guardrails need to have better than just like
directly
names that are
but it also raises the question of who's responsible for this, because I can imagine the case being made. I'm the AI developer. I've built this large language model. I've built this image generator. Isn't it cool? That's how I'm using it. Now I'm a subscriber who comes along and says, okay, I'm going to pay for this, but I'm going to use it in a commercial way that violates companies' IP.
Right. So historically, the cases we've seen arguments from the platforms, of course, trying to do the typical historic internet marketplace, social media company argument that we're just the marketplace. Anyone can come in and do whatever activity they want, including illegal activity, but we're not promoting that. We're not supporting that. We're not facilitating illegal activity. We can't help if people are bad actors in our space. We will, if we are aware of it, we will shut it down at that point. But we can't be held liable for activity that we were unaware of or reasonably could not have been aware of. And so that argument, though, is getting eroded a bit. We're seeing, and again, it's still early. A lot of these cases haven't been finalized through the appeal process. So I'm talking about where we are at this exact second on sand. But for the moment, I'm sensing that there's an appetite to reconsider that in this case. And so, because again, in a marketplace, you really can set up your pitch and you can reach out to certain people, and you can set up your own ad campaign, and you can set up your own storefront. And there's just much more control for the user over how they are going to engage in that commerce. And it is much more autonomous in that way. Within the toolkit that you're given, you have tools to use. With these GPT backed or these LLM backed GPTs, for the moment, because they're trying to do really streamlined, easy user interfaces, there are no toolkits. There's very limited. It's basically a search bar, a prompt bar, and that's it that most people use. And then some of us will go and use the plugins or the templates or the gems or whatever to try to get a little bit more refinement, or pick specific app integrations to do it, like Canva or whatever. But most people, I mean, there's just very limited tooling, and so the idea that the user is coming in and creating most of this opportunity is actually a little bit of a misnomer. So I'm not a betting woman, but I see that there is more in the tea leaves of these opinions. I'm seeing a little bit more appetite for questioning and pushing that. The other big issue that is arising is that a lesser used part of the Copyright Act and lesser litigated is now arising, and that is on the CMI elements. Have you guys heard about this at all?
No.
Okay. So I think it's copyright management information. That's the embedded metadata on all of these different files, digital files
Yeah.
for, any, visual, auditory, any kind of
I
these.
know that Sony and Adobe were trying to push something like that.
Right. And so it is actually unlawful to strip that out. And guess what the LLMs do? They don't want the bloat of additional data weight when they're doing this training. So the first thing they do is they strip out the CMI data so they can just get the material and just use that to train. And that appears to be a direction that could be a great exposure if it's not resolved with a carve out for this particular type of use.
Interesting.
Yeah. So that's an issue. So as I would say, if you don't have a CMI management layer, like application that's doing that for you as a agentic AI developer, right? Who's doing a layer app basically, or an agent. And I mean, the big companies know what they know the exposure, they're making those choices. They're aware of this. If you're building a backend LLM GPT, you need to hire a lawyer anyway. Like, just go do that. But if you're doing a layer app, like everyone's rushing to market right now, also you might want to just make sure that the way that you're training and doing inference for your layer functionality, and that your whatever tooling you're using to do that process for you, has a statement on what they're doing with the CMI data, and that you're aware, because that liability could impute both to them, but also to you as the customer who's requesting this process that is stripping out the CMI data. And we honestly, between you and me, I think just for the efficiency and for the energy efficiency, we got to come up. If we're going to allow people to train with all this massive amounts of data, and we know it's got CMI attached, we got to, and we're starting to say that's fair use, then we can't. This is a separate thing from fair use. You could be completely in the clear with fair use, but the moment you strip out that CMI data, that's a totally separate copyright claim, if that makes sense. And it's got big punishment attached to it. So we got to just get these things aligned, and right now they are not.
I wouldn't expect that we're going to get too much clarity in the not so distant future if it's anything that requires federal action.
Well, the good news is the courts are stepping in. They are the venue. And this is what happens when you have gridlock on the legislative front and on the regulatory front. The courts are still, they're still in business, and they're distributed around the country, even the federal ones. And so the good thing is that those judges are still going to work. So this is where a lot of these, unfortunately, it's more expensive for everybody, much more expensive. But this is the venue where you can get clarity. Having clarity to de-risk you is actually less expensive in the courts than, potentially gearing up a business worth, $3 billion, and now it's, it's got a fine regime that is hundreds and hundreds and hundreds of millions of dollars. So
if you had to say, if you were keeping track of things, kind of to see the direction we're heading in, what would you be paying attention to?
I really want to see the final on the BARTs. I think that Anthropic case is going to be super relevant. I think what's going to come out of it is not just whatever cover and allowance for a company like Anthropic to continue to exist. I think that the courts are hesitant to put businesses completely out of business, especially when they're of the market size that they are, and they could destabilize everything. It shouldn't be that way, but I think that they're not in the business of putting people out of business if there is a pathway. And so I think that one is going to be very relevant for that. But also, I think it's going to give us a lot potentially of unexpected clarity on some of these side issues that affect the rest of us who aren't building those
Makes sense.
backends. And then also the New York Times OpenAI case. I mean, I have clients that I'm very much watching it because I have clients that are doing editorial, right? So fair use under potential parody, but more under editorial comment and like sentiment analysis of news. And if we're going to go into a realm when that's less treated as search and then editorial fair use, and basically conglomerating so that you can just allow search, and we're going to say that this is going to be a more expansive embargo on fair use for them to protect news, then it's going to be much more difficult for all of us to evaluate what is truth and what isn't, because we won't be able to use, quite frankly, systems that are robust and as sophisticated as these media companies to evaluate them. We need somebody as the watchdog, and it's got to be just as high power of a tool to kind of keep up with the flow of these articles coming out and from all these different sources. So I really do hope that there's a ground there where we can preserve editorial rights to process, ingest, and comment upon news, as what that term means is seeming to be diluted quite a bit.
Well, I think this notion of, what is truth is something that, AI is continuing
challenge a lot
to
now.
Continuing to challenge. And, we'll need to bring in a philosopher to help us to figure that one out a little bit. But we are just about at time. We've actually gone a little bit over. Juliana, thank you so much for joining us today. We will have to have you back once we have a little bit of clarity on what these cases are suggesting brands should be doing.
Well, gentlemen, it was such a pleasure to be the third droid for the first time, the Droid Trio, to coming together.
Yes.
We've done this
Yep.
before, we just didn't call ourselves this, but now we can.
Yes.
Please bring me back when we launch the fully automated AI version of David to take over his droid seat. I want to be here for that big moment. And then when one of these cases hits, quite frankly, gentlemen, this is my official invitation for us to put out part 2 of our prior HBR article. We need
Absolutely.
we got to comment on it.
Sounds great.
And I think we should retire the purple droid only for Juliana.
We will retire the purple droid until we have a court decision that merits talking about.
There we go. We'll do it.
Thanks a lot, everyone. Thanks, Juliana, for joining us, and we will see you all in 2 weeks.
Bye.